You, the honorable judges of the Supreme Court, have just made a decision that a civilian should not be tried in a military court. There is what I call executive pushback, as is expected. The question is, did you make the right decision in accordance with acceptable international law? Yes, you did. Yes, you did. The question is that acceptable now? Politically, your decision is considered to be politically incorrect. In 50 years' time, you will be vindicated. And that is what warriors of justice must do at certain times. That which is unpopular now may much later be seen to be significant in the manner in which it pushes the agenda. You here in Uganda will remember when the administration of Idi Amin came into power, how the judiciary was dealt with. And you will remember a lot more vividly in 1979, during the transition from President Lule to President Binais, how Justice Wambuzi was dealt with. And one can go on and on to recount how judiciaries have been dealt with, calling into question what is the status of the judiciary in Africa. In the last few months, I've listened to a number of statements being made by African heads of state regarding the judiciary. In Kenya, I've listened to the head of state complaining about what he described as judicial overreach. Here in Uganda, in the month of November 2024, I heard Yoweri Kaguta Museveni, the president, saying, in reference to a decision regarding the parishes, that he would talk to the Chief Justice of Uganda and remind him that Uganda does not belong to judges and lawyers. It belongs to the people of Uganda. 2 days ago in Tanzania, the President of the United Republic said at a meeting of judges that judges must remember that they are not demigods. In other words, what we are seeing is what one may call agitation and conflict of a very unique kind, calling into question what is the exact role of the judiciary in post-colonial Africa. And it is not only in Africa that one sees this. If you allow history to inform you this afternoon, and you go to the United States of America in the very first administration post the Declaration of Independence, and you remember these immortal words of Alexander Hamilton, who was the first Secretary of the Treasury of the United States between 1789 and 1795, he said, and I paraphrase, of the three arms of government, the weakest is the judiciary. It possesses neither the sword nor the purse. And because of that, it is weak. What it has are judgments which are hollow unless they be implemented by the executive. That was in 1789. And you who are Ugandans and East Africa will remember a young Ugandan lawyer trained in the Soviet Union in 1967 saying, Picho Ali, in the transition, which was then a very important paper, transition number 36, is that he does not believe that the judiciary is independent. And in 1968, a man whom I came to know and visited in Mbale, the late Dani Wadada Nabudere, made a statement which has become immortal. He said, after all is said, I urge you to agree, and I agree with the Picho Ali, that there is nothing like independence of the judiciary, that the so-called independence of the judiciary is nothing but division of labor, and that what the judiciary does is to do that which is in the best interests of the economy and the ideology of the country. And he then went on to pose, but what is the ideology of a post-independent African country, which has inherited a system which is not rooted in his customs and his circumstances? This is the question that we honorable judges must confront today, because that is the reality. That, in my view, is the genesis of the crisis that informs African judiciary. It is not lost on me that the subject that you want to address is how the judiciary can be useful in the social and economic transformation of Uganda, and by extension, transformation of the continent of Africa. But it would be remiss on my part and on your part if we did not contextualize that discussion in history. And we must remind ourselves that the states that we have, whether it be Uganda or any other country, are products of a process. They are products of Berlin in 1884 and 1885. They are products of personal and commercial interests. When King Leopold of the Congo created the Congo Free State, which we now know as the Democratic Republic of Congo, and later called the Berlin Conference, which was held under the aegis of Otto von Bismarck, and the countries that we know today were divided into the 54 odd states. Each one of them followed a system of government that was informed by the colonizers. So that when you look at the legal traditions in all the countries, if you go to the so-called Francophone, and Africa is the only continent in the world whose countries are still referred to in those terms, so that if you are colonized by the French, you are Francophone. And indeed, if you visit and you read the history of many of these countries, you will see that their judiciaries are informed by the French tradition of civil law. Equally, if you visit countries that were colonized by the Dutch, such as South Africa up to a certain stage, the legal tradition is Dutch Roman. So that you are in Africa, in South Africa, and you are saying, my legal tradition is Dutch Roman. Countries such as Uganda, which were colonized by the British, also inherited systems that were characterized by what is referred to as the common law. But whose common law? The common law was the tradition of the English people. So that you, honorable judges, when you are writing your judgments and we talk about the reasonable man until very recently we used to say is the man or the woman in the Clapham omnibus. Not the man in a taxi in Kawempe, no, in Clapham omnibus. In Kenya, until Madan CBCJ, as he then was, said that the reasonable Kenyan man is the man in the Pangani bus, we still said that he was the man in the Clapham omnibus. That is how mentally conquered we are, and we must never forget that. That in our unguarded moments, we who are seated here, our minds are conditioned to think in a particular way. You honorable judges will remember times without number when lawyers appear before you, when they are citing Mukisa Biscuits case, they are not as animated as when they are citing Conway versus Rima. They think that Conway versus Rima is the acme of learning. That is who we are. But yet, in our Commonwealth or common law tradition, and honorable judges will remember these words of Lord Denning in the Nyali versus AG case, where he said that the common law is like the English oak. When it is transplanted and taken into a different environment, it does not grow with equal exuberance as it would in England. The same was repeated by Lord Atkin in Conway versus Rima. And you can see how my tone changes when I say Conway versus Rima. So what one is saying is that we are a people who are dealing with a judiciary that is not autochthonous or homegrown. And that is the reality. Even the systems of governance that we have are not autochthonous. We are described as Westphalian states. And therefore we have an executive arm, we have a legislative arm, we have a judicial arm. And you remember when Uganda regained independence in 1962, it did so on the basis of a Westminster model constitution, what you call the Republican Constitution. In 1967, I believe, if my history serves me well, the administration of Apollo Milton Obote attempted to bring in a constitution, the pigeonhole constitution, which history tells us that even those who had not read it said it was the best constitution, particularly those who had not read it. This was an attempt to indigenize constitution to answer to the post-colonial state. In 1995, after the administration of the NRM came into power, you'll remember that they experimented with a system called the movement system. And the whole idea of the movement system, as I understand it, was to begin to indigenize processes. Did it go far enough? No, it did not. In 1995, therefore, the process, or rather, prior to 1995, the Ugandans said, we are giving unto ourselves a Ugandan constitution. And those of you, and I believe all of you, have read Justice Odoki's book, in which he tells us blow by blow how they came up with the 1995 constitution, how they tried to make the different arms of the government be useful to the people of Uganda. How will the executive be useful to the people of Uganda? How will the legislature be useful to the people of Uganda? What kind of judiciary we'll have for the benefit of the people of Uganda? Because when we are talking about socio-economic transformation, in real terms, what do we mean? Let us unpack socio-economic. The African state is artificial. Artificial in the sense that Uganda has no less than 56 nations, which prior to the advent of the colonialists had their systems of governance. If you go to the Bunyoro Kitara, they'll tell you we had our own systems of government. If you go to the Batoro, they'll tell you the same. If you go to the Basoga, they'll tell you the same. If you go to the Baganda, they'll tell you the same. If you go to the Banyankole, they'll tell you the same. If you go to the Teso, they'll tell you we had our Emory Mori. If you go to the Acholi and everybody else, they'll tell you we had our own systems of the government, and then we were welded together into the thing that is now called Uganda. And Uganda, like all African nations, is work in progress. That work in progress is the one that wants to socially transform. Where does it transform and what does it become, that thing called Uganda? I remember as a young inquisitive student of history reading at one time, I think it was Napoleon or somebody else or Voltaire who said, with regard to the Roman Empire, he said the conglomeration that is normally referred to as the Holy Roman Empire is neither holy nor Roman nor an empire. The question is, our African states are still struggling. And when you want to transform them socially, you must do so with due regard to their diversity. If you want to make them the same, then you are losing the point. In other words, the Baganda are only good citizens of Uganda if their Bagandaness is allowed to manifest. The Acholi are only good citizens of Uganda if their Acholiness is allowed to manifest. The Basoga are only good citizens of Uganda if their Basoganess is allowed to manifest. If you suppress that, then they become a danger to the thing called Uganda. And that is what Professor Ali Mazrui writes in his book, The Power of Babel. Not the tower, the power of Babel. That this diversity can be dealt with in a manner that it strengthens us so that we have unity in diversity. Not the unity of the graveside, where there is silence which cannot be interpreted, is unity of purpose. The question is this judiciary capable of doing it? Let me take the simple question of the institution of marriage. When we were trained as lawyers in the common law system, you'll remember us being told that marriage is the union of one man and one woman to the exclusion of all others. When Telford Georges, that West Indian, was called upon to convict a person in Uganda prior to independence, and the man was charged with the offense of bigamy, said that he would not do so because that is not in keeping with the realities in Tanganyika then. He refused to accept that African customary law is only good as it is not repugnant to justice and morality. Because the question, whose justice, whose morality? Because in some African societies, marriage is the union of one man and one woman to the inclusion of all others. And if that therefore is the case, we must have a judicial system that acknowledges that reality. The Kenyan constitution, and I believe the Ugandan constitution now contemplates that polygamy is a recognized institution, and that you can register. The Kenyan constitution allows it, that you can register, this is my wife number one, wife number two, wife number three. The only thing is that you must make a decision at the very beginning. In other words, if you think you can be or you may be polygamous, don't enter into a union that excludes you. Don't go to the Attorney General's chambers. Don't go to a church, because that then becomes monogamous until you divorce. But if you go to Basoga customary law, Jopadola, Alur, then you are good to go. Am I saying this because it is important Because when we talk about social harmony, this is what must be done by the judiciary. The other thing that I'll talk about is land. Land in the capitalist system, when they came here, they told us that land is something that is the basis of commerce. And they came here with the whole idea that our lands were not owned by anybody. So in Kenya, we have a famous case called the Mulwa Gwanobi case, involving the Jibana peoples. When the British wanted to subdivide land, the people told them that land belongs to nobody, it belongs to God. The British administrator said, yes, we know it belongs to God, but the British administers it on behalf of God. And that is the basis on which you then have it registered as crown lands. If that be the case, if you want to create social harmony, how do you deal with land in Uganda? Amongst the Baganda, how do you deal with what you call the Milo land? How do you deal with land that is owned by the kings in Bunyoro Kitara? How does it become a factor of production? Because you are talking about social harmony and you are talking about economic transformation. Because if you don't take this into account, then you are going to suffer. And let me give you a very practical example. The Lapset, which was to be the pipeline from Lake, I don't like calling this thing Lake Albert, Lake Mutanzike, or Lake Bonyo, which you call Lake Albert. The pipeline was to move from that area through to Uganda, through to Kenya, and through to Lamu, Lapset. This is not said, but one of the reasons why it failed was because of compensation. On the Tanzanian side, because of the Nyerere doctrine of land, that land belongs to the state, there was no compensation, among other things. How do you deal with that? Because if you don't deal with it, then an economic project will collapse. I'm still talking about socio-economic transformation and the role of the judiciary. In other words, a judiciary must be a judiciary that is sensitive to the realities of the environment in which they are operating. If the judiciary is not separate and is not sensitive to that reality, then that judiciary will sooner become irrelevant and will be ignored by the executive without consequence. But am I suggesting for one moment that every executive fiat and diktat must be followed, that the judiciary must kowtow to the executive at all times or to the legislature? No. I'm not saying so. I am saying that what must happen is that it is incumbent upon the judiciary at all times to ensure that what it does is in the general good. But that begs the question, what is in the general good? What is in the general? Who is to be the judge of that which is in the general good? This is what your African presidents will tell you. The African president will tell you, I went throughout my country. I talked to the people. I was doing so on the basis of a manifesto. The people then elected me. And what I'm doing is in the best interest of the people. I told them that I would do this in land. I told them that I would do this as regards interest rates. I told them that I would do this as regards all critical areas of the society. And therefore, you who are elected by nobody, that's what they'll tell you. You who are elected by nobody, you have no business to tell me what to do. And if you doubt me, look at what is happening in the United States of America now. By dint of executive fiat, agreements that were long settled are being disturbed. Things which you thought were constitutionally settled are being disturbed. And the judiciary does not know what to do. How does the judiciary behave in such an environment as an agent of change?